G'day troops, my name is Maro, I figured you've got that by now, and welcome to today's case. Today's case answers the age-old question, who's the boss? In the case of Youtap and Johnston, there is a discussion about who exactly the employer is. Now, Youtap, as you can imagine, is a tap-and-go money kind of business, and there's a bloke called Dr. Johnston employed by the New Zealand entity to do some New Zealand work. However, through a series of fortunate events, he gets the opportunity to travel to Singapore and work in Singapore on kind of busting into the Asian market. There is a conversation about who exactly is employing this individual and on what terms. When he gets to Singapore, he gets some local advice and comes to the conclusions that he needs to be employed by a Singaporean company for the purposes of being there and being able to work, comes to the conclusion that he would like to move off KiwiSaver from a corporate perspective and make personal contributions, and fills out an employment agreement essentially to that effect. As you can imagine, some time passes, the relationship does not go exceptionally well, and there are some concerns around the relationship. A personal grievance ensues, and the key debate is who's in charge. The Employment Relations Authority comes to the conclusion that the New Zealand entity is, and let's just say there's not a huge amount of agreement between the parties on that point even after the case, so off to the employment court they go for a little bit more clarity on that issue. The court has a look at the facts and circumstances, considers carefully the situation, and comes to a few interesting conclusions. First and foremost, it says, look, you fellas appear to have signed an employment agreement in 2015 that appears to be on request of the employee, that appears to have been necessary for them to be able to operate in Singapore, and we think that's pretty clear a meeting of minds that the employment effectively novates. That is to say that the New Zealand entity removes itself from the employment agreement concept and that the new entity picks up those details or is in fact flatly replaced. But either way, the New Zealand guys are out. Now, the employee says, look, this isn't a sham, but it was kind of an idea to help us get along, but we all kind of knew this was the way that we were doing things. I sort of reported to these guys and my work was still kind of focused on New Zealand. Again, court has a bit of a look at this and says, well, look, it seems to us, mate, that you were probably doing this for the whole of the Asian-type business expansion. You volunteered for this process. You understood that enough to make your own private contributions to KiwiSaver. When we sniff test this, it just looks like what it is. You've moved to the Singaporean business. And so, on that basis, the court concludes that the employee has in fact shifted across and that the New Zealand employer cannot therefore be liable for any type of personal grievance. The message I think here for us to consider in terms of swapping out or moving around employers to agreements, be really clear about who's signing on to the agreement. Be really clear about if you're removing that party and moving someone else in, and be really clear about who's intending to be the party that actually manages the day-to-day aspects of the employment relationship. And if you do all of that, and you think about all that, and you write some of that down, you, much like Youtap in this instance, will be okay. Ladies and gentlemen, boys and girls, we've now answered who was the boss. I shall return your day to you, wish you the very best of luck, and I will no doubt see you again soon.